Estate planning is important in SMSF is because your superannuation death benefits is not automatically governed in your will. This means that when you die, your super death benefits is paid directly by the SMSF trustee. And without any planning, your super death benefits may not be distributed according to your wishes, and you might have some unintended consequences such as disputes, tax inefficiencies, or it might go to an unintended beneficiary. So it's important to have a death benefit nomination and to understand how they work.
Welcome to the Teaminvest Wealth Builder podcast, where we help you build smarter wealth and make more confident investment decisions. So welcome to this week's episode of Teaminvest Wealth Builder podcast. This week, we've invited back our self-managed super fund specialist, Melina. So we've had previous episodes where she's spoken on the different tax implications as well as structures around self-managed super fund. And this week, we're going to focus in on the topic of estate planning. So it's one of those topics that some people often avoid. You know, we get a little bit edgy talking about death and those sorts of things, but it's something that's really, really important. So it's something that we didn't want to shy away from on this podcast. So welcome back, Melina. It's so good to have you with us.
Hi, thank you so much for having me back.
Oh, you're very welcome. So let's jump straight into estate planning. So why is estate planning important within a self-managed super fund?
Estate planning is important in SMSF is because your superannuation death benefits is not automatically governed in your will. This means that when you die, your super death benefits is paid directly by the SMSF trustee. And without any planning, your super death benefits may not be distributed according to your wishes, and you might have some unintended consequences such as disputes, tax inefficiencies, or it might go to an unintended beneficiary. So it's important to have a death benefit nomination and to understand how they work.
And when you work so hard, you know, all your life to put together this, it's almost like your legacy, right? You've worked hard for this, so you want to make sure that it goes to the right people at the right time.
Correct.
So what types of death benefit nominations are available?
Yeah, so a death benefit nomination is essentially a legal instruction to your SMSF trustee when you pass away, specifying how you want your super death benefits to be paid. And a death benefit nomination comes in various forms. So you have binding or non-binding. So non-binding is just a preference, but it's not. It doesn't have to be legally enforced when you die. As a trustee, it retains full discretion in how they want to pay your death benefit, and your wishes can be ignored. Whereas a binding death benefit nomination is binding, obviously, to the trustee. To the SMSF trustee has to pay your super death benefit according to your wishes. Within that, you have what you call lapsing and non-lapsing. So lapsing is basically your death benefit nomination will expire after 3 years, and non-lapsing is obviously it continues on until it gets updated again. So it's always recommended to have your death benefit nominations reviewed, especially after major life changes such as marriages, death, a birth of your child, or a divorce.
Yeah, and I'm guessing it's would often be the last thing that people think about, right?
Yeah, correct. And the other thing is to make sure you check your trust deed as well, just to make sure, you know, your trust deed allows for, say, a binding or a non-binding death benefit nomination or a lapsing or non-lapsing. So everything goes down to your deed. It's also important to make sure your death benefit is also valid in terms of that it's signed correctly, dated, witnessed by generally 2 adults, and you have eligible beneficiaries nominated in your binding death benefit nomination.
So you've mentioned eligible beneficiaries multiple times then. So who is an eligible beneficiary?
Yeah. So under superannuation law, we have eligible beneficiaries, or also known as superannuation death benefit dependents. And these are people that you can nominate in your binding death benefit nominations. And they are your current spouse, married, de facto, or same-sex, are your children, either biological, adopted, or your stepchildren, your financial dependents, someone you're in an interdependent relationship with, or your legal personal representative via your will.
Okay, so let's pull that apart again. So you've mentioned a couple of terms that may not be familiar for people. So who can be considered a financial dependent?
Okay. A financial dependent is someone that relies on you for financial support at the time of your debt. And we've got to bear in mind that this is a substantial and ongoing relationship. And at time of death, generally, you need to be able, or the dependent will need to be able to provide evidence to support this, such as bank transfers, shared bills, or living arrangements together. An example of this is a grandchild who is being raised and financially supported by the grandparent, or an adult child who lives with a parent and relies on the parent for living expenses.
Okay, now that makes sense. You also mentioned an interdependent relationship. What is that?
Yeah. So I guess under super law, it's defined as a close personal relationship between two people who live together, provide financial, domestic, and personal support to each other. And the relationship must be substantial and ongoing. An example of this are, say, two siblings who are living together and are caring for each other, or a grandparent and an adult grandchild living together, sharing expenses and providing mutual care.
Right. Okay, that makes sense. So I noticed in your list that it didn't include parent or grandchild. So what if my death benefits need to go to them? So you've mentioned about the financial dependent, and you've mentioned about the interdependent relationship. Do they come under those?
Yeah, so by definition, I guess a parent or a grandchild or grandchildren are not superannuation debt benefit dependents. So meaning you can't just put them down as a beneficiary in your debt benefit nomination unless they meet the definition of a financial dependent or you're in an interdependent relationship with your parent or your grandchild. But if they don't meet that definition of financial dependent or interdependency relationship, and you put them down as a beneficiary in your binding death benefit nomination, your binding death benefit nomination will become invalid. Now, a workaround this could be to nominate your legal personal representative in your binding death benefit nomination as a beneficiary. And then in your will, you can specify that your super death benefits are to be paid to your parent or your grandchild or grandchildren.
Right. So the eligibility under the superannuation is different to under a will.
Correct. Yeah. So you just need to make sure that your will is updated to specify this as well.
Okay. So let's switch it up a little bit. Let's talk about death tax. That sounds like two exciting things both together. What is death tax?
Yeah. The death tax is basically the 15% tax paid on the taxable component of your super death benefit. Now, when you pass away, your super death benefit is made up of two components, your tax-free and your taxable component. And I guess your tax-free component are the non-concessional or after-tax contributions you've made in your lifetime. And your taxable component, which is made up of your concessional contributions, or your, pre-tax contributions that you've made in your lifetime, plus all the investment earnings that have added up in your SMSF over your lifetime as well. If your super death benefit is paid to a tax dependent, that becomes tax-free to the dependent or the beneficiary who receives it. So there's no death tax on that. But if your super death benefit is paid to a non-tax dependent, that's where the 15% death tax is applicable.
Okay, so tax dependence, how does this differ to the superannuation dependence that you mentioned earlier?
Yeah. So your tax dependents are, similar, very similar to your superannuation death benefit dependents. So you still have your spouse, you still have your financial dependence and your interdependency relationships. So you have the biggest difference is the children. So under a tax dependent, a child under 18 years old, a child who is permanently disabled, your child who's under 25 and financially dependent on you, or an adult children or an adult child who was financially dependent. All of these become what you call tax dependent. And when you're a tax dependent, any death benefits are tax-free in their name. But of the children, if you're an adult child, you're not a tax dependent. So that means any taxable component of your death benefit is subject to 15% tax plus Medicare levy, which is currently 2%.
Okay. So something, again, to be aware of if you're wanting to leave particular lump sums to particular people.
Mm-hmm.
So how are super death benefits paid?
Yeah, you have a choice of getting paid two ways, either a lump sum or an income stream or a pension, whichever one you want to call it. So if it's paid to a tax dependent, you can pay as a lump sum and these will be tax free. But if you choose to pay as an income stream or a pension, your tax is really dependent on, I guess, the age of the deceased and the dependent. So if either one of you, the deceased or the dependent, is over 60 years old, the income stream will be tax-free. But if both of the deceased and the dependent is under 60 years old, then the taxable component of the benefit that is paid will be subject to the dependent's marginal tax rate. But you do get a 15% tax offset with that. But then once the dependent or the beneficiary turns 60, then the income stream becomes tax-free. Another thing to note is that if you're an adult child who is not a tax dependent, their only choice is to receive the payment as a lump sum.
Right. Okay. So are there any other estate planning tools to consider?
Yeah, so we should consider like a reversionary pension and also appointing an enduring power of attorney as well.
So what is a reversionary pension?
A reversionary pension is a type of pension that automatically continues to the nominated beneficiary upon a member's death. So essentially, it's just a pension that continues as if the deceased was still alive, and the pension carries on and it just reverts to the nominated beneficiary on the reversionary pension. The pension continues under the same terms as when it was commenced, but a reversionary pension must be set up upon commencement of the pension when the member is still alive. And only one reversionary beneficiary can be nominated. So you can't nominate, your spouse and a child. You can only choose one. And it's important as well to check that your trust deed does allow for a reversionary pension. Most modern trust deeds do, but if you have an older trust deed, definitely worthwhile to get it checked out. And also check out your trust deed that your reversionary pension may take priority over a binding death benefit nomination if you do both.
Okay. And the other tool that you mentioned was enduring powers of attorney. So how do they work in an SMSF?
Yeah, so if you become incapacitated, that means then you're no longer allowed to be a trustee or a director of a corporate trustee. So you have to step down as a trustee, and that's where your enduring power of attorney or your EPOA takes over the trustee responsibility for you. So then we essentially appoint your attorney as the individual trustee or a director of your corporate trustee. And this allows them to make decisions on your behalf, such as liquidating assets, cashing your members' benefits, so taking out your pensions or your lump sum, or rolling out your benefit to an APRA fund or a retail fund, or winding up your SMSF for you.
Okay, so both of those tools that you pointed out, the reversionary pension as well as the enduring power of attorney, they both need to be set up either before you pass away or before you become needing them, basically.
Yeah, so with a reversionary pension, if you're about to commence a pension, have a think about whether you want a reversionary pension in place, because that's the only time you can set that up is right at the beginning when you start a pension, because it needs to be documented in your pension commencement documents. And I guess having your enduring power of attorney, it should be part of your general estate planning, with your wills and everything else that you do outside of the SMSF.
Wow. Okay. So we've gone through quite a few different points with estate planning. Is there anything else that you would like to tell our listeners that they need to know about estate planning?
Yeah, so this is something you definitely need to think about sooner rather than later, and review it. Review it, every couple of years. Review it when, something happens in your life, such as, marriage or a death of a member of your family, a birth of a child or a grandchild, and review it as part of your whole estate planning, not just for your superannuation.
Oh, no, that's wonderful. Thank you for your wisdom, Melina. It's always wonderful to talk to you and learn more about self-managed super funds and all of the different things that we need to think about on a regular basis. I'm sure our listeners have got a lot out of this episode. And once again, if they have any questions or are interested in setting up a self-managed super fund, how can they get in contact with you?
Yeah, you can contact me on SMSF at tipgroup.com.au.
Wonderful. Thank you so much, Melina. We'll leave it there, and I'm sure we'll have you back again. Thank you for joining us.
Thank you for having me today.
The information contained in this podcast is of a general nature and is not intended to address the objectives, financial situation, or needs of any particular individual or entity. It is provided for informational purposes only and does not constitute, nor should it be regarded in any manner whatsoever as advice. It is not intended to influence a person in making a decision. No one should act on such information without appropriate professional advice after a thorough examination of their particular situation and needs. Thank you for joining us on this episode of Teaminvest Wealth Builders. We hope you found today's discussion insightful and inspiring. If you know anyone else who could benefit from hearing this episode, please hit the share button and pass it on. If you'd like to learn more about Teaminvest or our unique investment approach, visit us at teaminvest.com.au. And please don't forget to subscribe to the podcast for more episodes. Until next time, stay informed, stay invested, and keep building wealth.